Good afternoon and welcome to the weekly business meeting of the South Carolina Public Service Commission. Today is Thursday, June 5th, and it's approximately 1 p.m. Before we begin this meeting, would you please join me in a moment of silent reflection? Thank you very much. All commissioners are present in the hearing room. Ms. Scarborough, before you begin, I'd like to go ahead and point out, save a little time, Commissioner Britt has joined us since we heard three of these matters, items 3, 4, and 6, and he will not be voting on those. If I call your name, please say not voting in case I forget. Thank you, Mr. Scarborough. Would you please proceed?
Yes, sir. Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the next the date of the next business meeting. Staff recommends that the next regularly scheduled Commission business meeting be set for Thursday, June 19th, 2025 at 1 p.m. We also note that the Commission has scheduled a special business meeting for Thursday, June 12th, 2025 at 1 p.m.
That is correct. The next regular business meeting will be on June 19th at 1 p.m. and a special business meeting will be held on June 12th at 1 p.m.
Yes, sir. Today we have 7 items on the utilities agenda and 17 items on the transportation agenda. Item number 1 is in docket number 2013-380S. This is a request from Ocean Lakes Utility LP for approval of an increase in its wastewater fees via pass-through rates effective July 1st, 2025.
Thank you. As to item number 1, is there a motion?
Mr. Chairman,
Commissioner Belser.
thank you. I move that the Commission approve the request for an increase in the pass-through wholesale wastewater rate from the current rate of $3.74 per thousand gallons to $3.89 per thousand gallons, effective on July 1, 2025, contingent on Ocean Lakes following and complying with the following conditions. First, Ocean Lakes is directed to file with the Commission proof that the notice of proposed increase was provided to all customers at least 30 days in advance of implementing the proposed pass-through rate increase and change. And second, Ocean Lakes is ordered to file with the Commission proof that the Grand Strand Water and Sewer Authority Board of Directors has approved the proposed wholesale wastewater rate increase of 15 cents per thousand gallons. The current rate of $3.74 per thousand gallons will be increased to $3.89 per thousand gallons effective July 1, 2025, if approved by the Grand Strand Water and Sewer Authority Board of Directors. These conditions and required filings must be provided to the Commission before Ocean Lakes may implement the requested increase in the pass-through rate. I move that the Commission find and conclude that Ocean Lakes Utilities is acting in compliance with and following the procedure established by Commission Order Number 2014-48 for Ocean Lakes to pass through its retail sewer customers the amount of increase in the wholesale rate charged to Ocean Lakes by Grand Strand Water and Sewer Authority. Ocean Lakes has provided a copy of the customer notice which Ocean Lakes intended to issue to customers 30 days prior to the effective date of the new increase. Ocean Lakes has also provided the 30 days notice to the Commission by filing the notice received from Grand Strand Water and Sewer Authority advising of a proposed increase effective July 1, 2025, which is expected to be approved by Grand Strand's Board of Directors on June 23, 2025. Finally, I move that the requested increase relates only to the noticed increase in the wholesale wastewater rate by Grand Strand Water and Sewer Authority for July 1, 2025, and does not implicate or approve any increase proposed or contemplated by Grand Strand Water and Sewer Authority in 2026. I so move.
Thank you, Commissioner Belser. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
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 Those opposed by no. The ayes have it. The motion carries.
Item number 2 is in docket number 2025-61WS. This item involves a request for waiver of hearing, the joint application for approval of the partial consolidation and the stipulation entered into by Kiowa Island Utility Incorporated, South Carolina Water Utilities, CUC Incorporated, South Carolina Water Utilities Incorporated, and the Office of Regulatory Staff.
As to item number 2, is there a motion?
Chair Powers,
Commissioner Caston.
thank you.
I move that the commission find and conclude that a hearing on the application of Kiowa Island Utility Incorporated, South Carolina Water Utilities Incorporated, South Carolina Water Utility CUC Incorporated, for approval of partial consolidation and request for waiver of hearing is not necessary in the public interest or required for the protection of substantial rights, and therefore grant the request for waiver of hearing. The application indicates that neither the rates charged nor the service provided by the applicant will change if the application is approved. The application further indicates that the applicants are wholly owned indirect subsidiaries of Nexus Water Group Incorporated, a corporation organized under the laws of the state of Delaware. Nexus and its subsidiaries provide the applicants with management, operations, and financing support services. Nexus will continue to provide services to the consolidated entity. Next, I move that the Commission accept and approve the stipulation entered between the applicants and the South Carolina Office of Regulatory Staff. I further move that the Commission find and conclude that the application, subject to the stipulation, is in the public interest. The application involves the partial consolidation of the South Carolina Water Utility CUC and South Carolina Water Utility Water and Sewer Systems in Beaufort County with Kiowa Island Utility. The consolidation will include two transactions. One, the merger of South Carolina Water Utility CUC and Kiowa Island Utility, with Kiowa Island Utility being the surviving entity. And two, South Carolina Water Utility will transfer the assets and liabilities of the Harbor Island and TJ Barnwell systems to Kiowa Island Utility. The consolidation will include the transfer of water and sewer facilities, territories, and certificates of public convenience and necessity. Finally, I move that the Commission's approvals of the stipulation and application are conditioned upon the applicant's issuance of a Commission-approved notice, a proposed draft of which has been submitted to the Commission by the applicants to any and all affected customers with no protest or petitions to intervene filed by any customers within 15 days after the issuance of such notice. I so move.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion?
Mr. Chairman,
Commissioner Belson?
and may I ask a question first?
Absolutely.
Commissioner Caston, I think that the intent of this motion is to approve both the application and the stipulation, that's subject to the notice going out after the fact. Is that correct?
Yes, ma'am, it is.
Could I ask that somewhere in I think the paragraph where you referenced, next, I move the Commission accept and approve the stipulation entered into that, I think there was a sentence that said, I move that the Commission find and conclude the application subject to the stipulation is in the public interest. Could we move and approve the application? there?
Absolutely.
Okay.
Yes, ma'am.
Just for clarity, if we could, I would just, at the end of that part, just and approve the application and stipulation or something to that effect. For
Yes,
clarity.
thank you. I believe that is very beneficial.
Thank you. I'm not trying to change the intent of what I think you were moving. I just was trying to clarify a little bit.
I think that does. Thank you very much.
Yes, thank you, Commissioner Belson. Having heard the,
Ask that be considered a friendly amendment and accepted to move forward.
and is that accepted as an amendment, Commissioner Caston?
Absolutely.
All right, thank you very much. Having heard the motion and the amendment as presented, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 3 is in docket number 2024-303E. This is a petition from Duke Energy Carolinas LLC and Duke Energy Progress LLC for reconsideration of Commission Order number 2025-299.
As to item number 3, do I hear a motion?
Chair Powers.
Commissioner Caston?
Thank you. I move that the Commission grant the request of Duke Energy Carolinas LLC and Duke Energy Progress LLC for reconsideration of order number 2025-299. Since the issuance of order number 2024-299, the Duke companies and the Department of Consumer Affairs have been able to resolve all outstanding issues and have executed a stipulation. Southern Alliance for Clean Energy, Coastal Conservation League, Vote Solar, Upstate Forever, and the Office of Regulatory Staff have filed letters of no objection to the stipulation. In recognition of the now complete resolution of all issues outstanding, I move that the Commission vacate order number 2024-299 and that the Commission approve the request to make modification to the Duke Company's residential and non-residential demand-side management and energy efficiency programs as filed, subject to the stipulation between the companies and the Department of Consumer Affairs and the recommendations of ORS to which the companies have agreed. I so move.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion?
Chair Powers.
Commissioner Williams.
I just wanted to add my thanks to Commissioner Caston for that motion and my appreciation to the companies and to the Department of Consumer Affairs in working out this stipulation, and I'll be supporting your motion.
Thank you, Commissioner Williams. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 4 is in docket number 2024-151E. This is a request from Duke Energy Progress, LLC, for leave to file its report on the Robinson Plant Rockingham 230 kV transmission line rebuild for the first quarter of 2025 on a delayed basis.
As to item number 4, is there a motion?
Mr. Chairman,
Commissioner Belser.
thank you. On September 23rd, 2024, the Commission entered order number 2024-640, which granted the request of Duke Energy Progress, LLC for a like facility determination regarding the replacement of the Robinson Plant Rockingham 230 kV line and associated structures. The order required Duke Energy Progress, or DEP, DEP, to provide updates on the status of the project every 3 months until completion. DEP's second quarterly report was due on March 31st, 2025, and was submitted on May 22nd, 2025. DEP indicated that the delay was due to an oversight and request leave to file the report on a delayed basis. I move that the Commission grant DEP's request and accept the late filed report. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is there any further discussion?
Mr. Chairman, I would just like to note, if I may, that we ask for a lot of reports from the various utilities at times, and those are usually very timely filed. I can understand an oversight every once in a while. We just certainly don't want anything to be a recurring theme. But I certainly understand, because I miss deadlines too, how it can happen occasionally. Thank you.
Thank you. Is there any further discussion? All those in favor signify by saying aye.
Aye.
Those opposed by no. Motion carries. Ayes
Item
have it.
number 5 is in docket number 2024-336E. This item involves the oral arguments held before the Commission on May 21st, 2025.
As to item number 5, do I hear a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the Commission revisit the legacy net energy metering methodology in accordance with South Carolina Code Annotated Section 58-40-20E. In order number 2021-569, by accepting and reviewing filed comments from the parties as opposed to conducting a hearing. I further move that the Commission adopt the following procedure schedule for the comment proceeding. September 30th, 2025, initial comments from Duke Energy Carolinas LLC and Duke Energy Progress LLC, along with Dominion Energy South Carolina. November 14th, 2025, comments by the South Carolina Office of Regulatory Staff and Interveners in response to initial comments. December 15th, 2025, reply comments by Duke Energy Carolinas LLC and Duke Energy Progress LLC and Dominion Energy South Carolina. And Commission order by March 15th, 2026. So moved.
Thank you, Commissioner Vice Chair Williams. Having heard the motion by Vice Chair Williams, is there any further discussion? Hearing none,
Chair Powers, I'd like to make a
Commissioner
comment.
Williams.
Vice Chair Williams, I am, I don't know what to put the percentage on, how much I support this, but most of this I do support. I have a philosophical concern with indicating that we will not hold a hearing at this point. It is not based on anything particular that I heard in the oral arguments. It is more of a, we don't know what will come from these comments, and therefore I am not comfortable with committing, which is the way I read this, to not having a hearing. So I would be supportive of your motion if it, at the end of your first sentence, it ended with reviewing filed comments from parties and struck as opposed to conducting a hearing. I'm not making that as a friendly motion because I'm not sure exactly where you are with that, but I wanted to articulate that position, that concern.
Yeah, thank you. I really appreciate that. That's one of the interesting parts about life here on Earth. It's hard to know everything, but let's just talk about what we do know. I think we know, and I stand to be corrected, subject to check. I think we know that the Duke companies and Dominion Energy South Carolina don't plan on requesting changing the existing methodology. Is that fair? Would you agree that we know that?
I don't think we know it in a concrete way. I think that's what's been suggested in the oral arguments.
And also in the filings in this
Right.
docket?
Right.
Okay. And we know that no party, based on what has already been filed, has requested a hearing based on concern regarding what the companies, the utilities have already filed?
That I beg to differ there. I do know that most of the parties have not have indicated support for no hearing. However, one party did talk about items, say things like it's difficult to say whether a hearing would be necessary, and I read that as wanting to leave the option open. Again, I am not predicting that we will need a hearing. It is, and so I question the amount of debate that's needed for this by my own self, but I believe that because of the unknown, it's important for us to keep that possibility open.
Yes, ma'am. And in a general sense, I agree with you. It's good to keep options open when there are unknowns. But based on what we do know, some of which I've brought up, I think that the commission is more than capable of making a decision without a hearing based on what has been filed regarding what the companies, the utilities plan to do, even based on some of the concerns mentioned by some of the other parties. What strikes me is that if the advocates that appear before here are some of the best I've seen, and they are strong in their convictions and their positions, and if no one is requesting a hearing right now, I think that there are limited, if any, real concerns for there to be a hearing, and as opposed to allowing the opportunity for an effective and efficient decision to be made ultimately on what we receive, just my view is more appropriate to move forward with the motion as written.
Given what you just said, if a party determined that a hearing would be valuable and warranted and requested a hearing, would that be an opportunity for the commission to revisit that question?
I think that definitely would be an opportunity for the commission to revisit that question. I don't know what the outcome of that would be, but if someone felt that they need they
Right.
had the right to file
Right.
a
Well,
petition.
I may vote no on your motion, because I'm concerned that it could be used, against us in the future should a party believe that a hearing is necessary. But I do appreciate that you are acknowledging the right for the request. I just feel like we need to be more open to more than just the right. We need to be able to evaluate the facts at the time to determine whether there's a hearing.
Commissioner Williams. Oh, I guess that means which one?
Well, he's vice chair.
The one with the shiny head.
Chair Powers, may I?
Commissioner Caston.
Thank you. I get both points. I think excellent. I guess independently, I share a similar concern to Commissioner Carolee Williams in that, as I recall, one of the attorneys in particular for the interveners, did say, it could require it, but may not, depending on, what information is provided. I guess the only thought I have, or I would put forth, is I don't foresee the need for a hearing, but I also don't see where there would be a problem with the motion that leaves that possibility open in the event, once the information is provided, that if something unique or odd does come up, that it's pretty much a non-issue. I don't want to feel like I'm making a decision before I know what all the information is. Does that make sense or resonate? Start with Commissioner C. Williams.
I'll just say that is exactly what I would say if I was in, that's what I intended to be saying. So I agree with you. Thank you.
Any further discussion?
Commissioner Caston, Mr. Chair, I would just offer to Commissioner Caston, I think we may have a different view on the decision to be made. I think the decision to be made based on the filings would be whether or not to change the methodology. The decision here is just whether or not we will move forward with a comment proceeding or a full hearing. And at this point, again, I think the motion is appropriate, but it's definitely. I don't think you were suggesting that it was any level of a predetermination. I don't think you were suggesting that. But in terms of the decision, the only decision here is just a decision to proceed with a hearing or a comment proceeding.
I concur with that, and based on that statement, I'm going to go out on a limb and offer a friendly amendment to just eliminate the words "as opposed to conducting a hearing."
So, with all due respect, I don't. With all due respect, I think the intent of the motion as it stands is to move forward with a comment proceeding that doesn't anticipate a hearing, the need for a hearing. So I don't think that's a friendly.
We're not very far off, but I appreciate that response. That was just I wanted to offer it in case you had adjusted your perspective. Thank you.
Yes, ma'am. Thank you.
Final comment. I want to make sure I understand this too. Along the lines, Vice Chair, of what you said, it's not about whether to change the methodology. That I agree, but how to revisit it if necessary. I guess. So give me a second here. Let me ponder this. I, may I offer a substitute motion?
We will certainly entertain a substitute motion.
On May 21st, 2025, Commission heard oral arguments in this matter. Prior to the oral arguments, certain interveners proposed a full procedural schedule to include a full evidentiary hearing. However, at the time of the argument, CCL and SACE agreed that an initial comment schedule could be sufficient to avoid the need for a hearing. Therefore, I move that the Commission instruct the Clerk's Office to issue the following procedure schedule for comments and responses as follows. September 30th, 2025, initial comments from the companies and Dominion Energy South Carolina Incorporated. November 14th, 2025, comments by the South Carolina Office of Regulatory Staff and interveners in response to initial comments. December 15th, 2025, reply comments by the companies and Dominion. And a commission order no later than August 19th, 2026, which I think was what all the parties agreed would be the statutory deadline. That's my proposed substitute motion.
All right, so as to the substitute motion, is any further discussion?
Mr. Chairman,
Commissioner Belson?
in this substitute motion, you're not saying that that a full-blown hearing is going to be had, is that correct?
Yes, correct. That's correct. Because, yes,
Okay.
I don't think one is needed. It didn't seem like the parties thought it would be needed, but it doesn't close the door to it if whatever information comes available.
Thank you.
Chair Powers?
Commissioner Williams?
Just for clarity of the record, Commissioner Caston, at the end of your motion, you said something like, at the section where it said commission order no later than August 2026, which I think all the parties agreed to was the statutory deadline. Is that a part of your motion?
Yes,
It was kind of a trailing off, so. I
Well, he
wanted-
said August
I said
19th,
August 19th.
2026.
Thank you.
And if that is the incorrect date, I certainly stand to be corrected on
No,
that.
I'm really asking if the phrase, which I think all the parties agreed to was the statutory deadline, if that's part of your motion.
Yes, that's
Okay,
fine.
thank you.
All right, any further discussion?
Mr. Chair. Just a question about the what Commissioner Caston anticipates would happen here. So, I think your motion anticipates there'd be a comment period, right? A comment period.
Yes,
So essentially a paper proceeding.
yes.
Okay. And so the parties are going to put forth whatever effort, resources, time, money it takes for that process. And if a hearing arises or a need for a hearing arises, how do you see that happening?
After that information, excuse me one moment. Are you talking about like from the initial comments that are due in September, or all of the comments in general?
Well, I think it probably could happen a number of ways, but just say when all the comments are, I mean, I'm not really sure. It could happen a number of ways, but if a party or if the commission or someone said, "Hey, we need a hearing," when would that happen? Or how could, in your view, based on what you anticipate happening, when would the need for a hearing happen? When would that arise, or when could it arise?
Well, I would think it would arise after the comments from all parties have been received, and if there's any question or concern. For example, I think one of the attorneys for the SACE and CCL, said it could require a hearing, but certainly the attorney didn't sound as though thought that would be necessary and that this was a good method to do it. But after receiving all the information, and if perhaps the parties, it may be CCL, SAFEs, were not satisfied with that, perhaps then.
And so if a party is not satisfied, so I'm just trying to think it all the way through. So if a party is not satisfied with information received in a comment, then what?
Are you going?
Commissioner Caston, can I make a suggestion
Yes, you
to
may.
your powers?
Certainly.
As I listen to you, Vice Chair Williams, what I think might be necessary is an addition of a date and a deadline for a response from the parties. And I think that would only happen after the December 15th, 2025 deadline where the reply comments are due. And just to put something out there, I looked ahead. I mean, it could be something like January 5th. It could be something like the end of December. But I'm wondering if a reply deadline for a request for a hearing would answer your question to make it clear that we have heard from all parties with regard to the idea of a hearing. Because the last people to speak in this schedule would be the companies.
Right. I mean, so I like to think things. One of my weakness, strength, depending on who you ask, I really like to think things through before I commit to them. And I'm trying to, as I think this through, it seems to me this could create a situation where we have the parties file their comments, and so they're doing work there. And let's just say a party, so we already know what the utilities are going to do. At least based on their filed comments, they plan to not request any change to the methodology. We know that today, while it was said it could be a need for a hearing, we know that nothing that exists, nothing that has happened in the world has created the need for a hearing based on the parties. But let's just say something does come up. It almost puts us back in the same position where we have to decide whether or not a hearing is necessary. And I'm just wondering, how do we weigh that? If one party just says, I think we need a hearing, then we're in the same position again, it seems. As long as we know that as long as we know and accept that we could put ourselves in a pretty tight situation procedurally.
Vice Chair Williams, I don't mean to be suggesting that we would affirmatively hold a hearing if requested. I think it depends on the details. It depends on what comes out in the comments, the initial phase, in the phase in November, and ultimately.
That's a good point. Let me ask this question then. What if no party requests a hearing? The commission or this motion doesn't create the opportunity to set a hearing based on a desire for more information, does it? Let's say a commissioner say, you know what, I think I want a little more information. Let's go ahead and set a hearing. What you have is good, but parties, but I want a little more information, so let's go ahead and set a hearing. This motion doesn't create the situation where that could occur, does it?
I do not think it does. I know that's certainly not the intent. Again, I do not anticipate a hearing be required. But at the same time, having sat through the oral arguments, that's just the attorneys. And I know we did have the utilities file comments. But when, I can't remember if I asked the question, you asked the question, or multiple people asked the question about, so you don't think a hearing needs to occur. And the attorney for, say, CCL was not as definitive. So I guess trying to show a certain degree of deference for that. I do not see the downside. I understand what you're saying. Okay, at what point would it be triggered? I guess you'll know when you get there. But conversely, if your motion was adopted and it says we're not having a hearing, and if the information that is provided, which I don't anticipate it being an issue, but if it is, and there is some issue that either maybe commission may have or the intervener may have, what then would be the recourse or method for the intervener or whomever to revisit that?
I think they would petition the commission for a hearing.
I don't think it would need to be a petition. It would just be a request or a motion.
And they can make
I mean, if you're using the word petition as a verb generically and not as a legal pleading, I agree, but.
Right. I understand what you're saying. I was using it as a verb. But yeah, they would file a motion requesting a hearing. I mean, that's what they could do. I mean,
okay. That said,
if they felt that they needed that, they could bring that information to the commission at the time. But the intent and the purpose of my motion is to give certainty to the parties that the commission is prepared to receive comments and make a decision as outlined in the motion.
I understand that and appreciate it. Mm-hmm. But I guess following the logic that you talked about is if they wouldn't have to petition but request a hearing, either via the motion, the substitute motion I proposed, or your motion, and then those events occur and a party requests a hearing, then that time constraint or that you had mentioned would still be the same. I guess what I'm saying is, based on what I'm hearing from you and your logic, and I'm not criticizing it at all, I think it's excellent. And what I'm proposing here, both can and would lead to the same place, but I just think one is a little more open and accommodates concern somewhat expressed by one of the parties. That's all I'm saying.
Okay. And so I think Commissioner Caston, what I've heard from you is that your motion is to I'm going to use this phrase, it's been used a couple of times, leave the door open or make room for a hearing in case a party believes a hearing is necessary. And in this case, it seems that party would be SACE and CCL. If they believe a hearing is necessary, your motion leaves space for them to say so, essentially.
I would say that's a possibility, but it could be any party.
Any party. But the motion does not create space and opportunity for the commission to review the comments and then say, from the bench, we believe that a hearing is necessary.
Repeat that.
So I understand a party filing a motion for a hearing, and I agree with you. Regardless of the motion, the mechanism would be similar. If a party believed a hearing was necessary, they would make the request. If that doesn't happen, let's say that doesn't happen by put it January 1st, then the commission is postured to make a decision, put this on the agenda and make a decision as soon as they're ready to, as we're ready to make that decision. We're not going to hold the matter hostage.
I think I understand that, and I think the commission always has that ability, but are you suggesting an amendment to my substitute motion that
Oh, no.
a date be added?
Well, I mean, I don't want to do that to you in the moment, unless you're prepared for that. The purpose of this is just to talk through it, to figure out what you're thinking, because that August, I understand what the statutory deadline is, but 6 months I think is a long time. Let's say the hearing does not happen. 6 months is a long time to, in my opinion, have a matter when there's an opportunity for us to decide it, get an order drafted and issued.
I agree. So having this discourse, which I think has been very beneficial, if it would help or benefit to add a date after December 15th, whether that's January 1, January 15th, January 30th, as you alluded to, I'm not averse to doing that at all.
Okay. So are you, again, we're doing this, we're building a plane while we're flying it. Is a January 1st deadline to request a hearing?
Well, that would be a holiday, but
January 2nd is a Friday. It might be more appropriate.
I'm open to that. So is January 2nd, are you comfortable with January 2nd being a deadline for any party interested in requesting a hearing to do so?
May I just ask,
Commissioner Melton.
I'm sorry, it's just, I'm a pile on here with regard to the date. There's a lot going on for everybody, commission, parties at the end of the year. I would at least move it out to the end of the first full week, if not this, make it January 15th, which is a month after reply comments. There's a
fine with
lot
that.
of stuff going on for us. There's a lot of stuff that the parties are doing just in normal business at the end of the year. And, they need to be able to look at those comments and give it their attention.
that's good with me.
I'm
I
not
think.
trying to drag this out because I think that we need to,
I think that's
once the comments come in, we're going to have to do our part and get through them and be able to make a decision. But at least we need to allow the parties the opportunity to. And that's just, that didn't preclude them from filing something earlier.
Right.
No later than.
Right.
I like
mean-
that too. I agree with that.
But I know that it gets crazy at the end of the year for
It
everybody.
does. Are you okay with that, Vice Chair?
I am.
It's
So what I would suggest is
On or
request
before?
for a hearing no later than January 15th, 2026. Does that sound like what we've been talking about?
I think so. And I would just add, that doesn't preclude us from, engaging in our work as going through these materials either. Just because we got a date for them to request by doesn't mean that doesn't keep us from going through and working through the materials ourselves. So just in preparation to going through them. So
And Commissioner Caston, I think that date helps out a lot just for planning for everyone involved. But I would ask if you're open to setting a March 15th, or no later than March 15th deadline for the commission order, if no one requests a hearing by January 15th.
absolutely, sure.
because I mean, we know, I understand the purpose of putting the statutory deadline in the motion, but I think all the parties and the commission knows about or is aware about the deadline, the mandatory statutory deadline.
I agree, and I don't think there's any desire by anyone to drag anything out, certainly not mine. I know not anyone on this commissions, and I don't think any of the parties, so, I think these have been excellent points and additions, and kind of like no harm, no foul. Yes.
Chair Powers
Commissioner Williams.
and commissioners, I think, but I want to just double check that the March 15th deadline gives us the ability to incorporate the results of the avoided cost proceeding. Is that correct to your understanding, Vice Chair Williams and Commissioner Powers, Chair Powers?
I think the avoided cost proceeding orders have to be out well before the end of the year.
Thank you.
That's
Commissioner
my
Pelzer.
recollection.
All right, are we adding to the substitute motion? Or are we adding to the original motion? And whichever it is, would you
Yes.
please read it again so we'll know what we're voting on?
I will. And I hope you guys will fill in the blanks if I messed it up. On March 21st, 2025, the Commission heard oral arguments in this matter. Prior to the oral arguments, certain interveners proposed a full procedural schedule to include a full evidentiary hearing. However, at the time of the argument, CCL SACE agreed that an initial comment schedule could be sufficient to avoid the need for a hearing. Therefore, I move that the Commission instruct the Clerk's office to issue the following procedure schedule for comments and responses as follows. September 30th, 2025, initial comments from the companies and Dominion Energy South Carolina, Incorporated. November 14th, 2025, comments by the South Carolina Office of Regulatory Staff and interveners in response to initial comments. December 15th, 2025, reply comments by the companies in DS and Dominion. January 15th, 2026, request by any party for a hearing no later than January 15th, 2026. And commission order no later than March 15th, 2026. Does that sound right?
Chair Powers?
Commissioner Williams?
Commissioner Caston and Vice Chair Williams, I think that March 15th date was offered only if we did not go to hearing, and that we would, if we would keep the August deadline should we need to have a hearing, understanding that August is the statutory deadline, and also understanding that we're not anticipating
Okay.
a request for a hearing. But I think we need both in the event that we do have a hearing.
All right. Could you suggest that verbiage?
Vice Chair Williams, is that within the scope of your thinking?
Yes.
Okay. So I think that where you read the date about March 15th, that March 15th is
If no hearing.
March 15th deadline for commission order if no hearing is requested.
By January 15th.
You could combine those two.
If a hearing is requested, I mean, I don't know if we have to say it, but if you want to say it, the August 19th, 2026 deadline, the commission will issue an order by August 19th, 2026.
By any chance, Ms. Moser, did you capture that? I did. Good.
For clarity's sake, I'm going to ask that the motion be repeated now that,
Mr. Chairman, I have a clarification I'd like to ask about for the motion.
certainly.
I think, and Commissioner Caston's motion, he referenced the companies and Dominion Energy. I think we need to be clear that that's Duke Energy Carolinas LLC and Duke Energy Progress LLC and Dominion Energy South Carolina.
Correct.
If we could.
Correct. It becomes too common for us. I appreciate that.
Thank you.
Now, Ms. Moser, did you get all that?
I did, Commissioner Caston.
I'm still gonna ask you to reread the motion.
Can we just get to the schedule part? Because I
Yes.
think that's the
Yeah.
only, if we could, Mr. Chairman, I don't mean to step on toes, but I think that's the crux, is it not? The schedule part?
All right, let's try this then. The first paragraph is
As is.
as is. September 30th, 2025, date is as is. November 14th, 25, date is as is. December 15th, date as is.
With one exception, two exceptions. September 30th, you would identify it's the Duke Energy Carolinas and Duke Energy Progress, and the same for the December 15th date.
Correct. And Dominion Energy. And after the December 15th, well, the December 15th, same thing, Duke Energy Carolinas, Duke Energy Progress, and Dominion Energy, South Carolina. And after that, no later than January 15th, 2026, let's see, request by any party for a hearing no later than January 15th, 2026. And if no hearing is requested, order be issued by March 15th, 2026. If a hearing is requested, commission order no later than August 19th, 2026. I so move now.
All right. Any further discussion? Hearing none, we're going to proceed to a roll call vote on this, beginning with Commissioner Caston.
Aye.
Commissioner Britt.
Aye.
Commissioner Thomas.
Aye.
Vice Chair Williams.
Aye.
Commissioner Williams.
Aye.
Commissioner Belser.
Aye.
And I vote aye. The motion carries.
Item number 6.
Mr. Chairman, I apologize, and I have a clarification that I would like to make on item 3, and I don't know whether to do it now or wait until we finish the utilities agenda.
Let's go ahead and do it now.
Okay, it's really not, it's not a change to the motion, but I think the order that was, issued originally and for which reconsideration is sought or was sought is order number 2025-299. I think in maybe reading the motion, a couple of places, the order was referenced as 2024-299. And could we just make sure that the motion accurately reflects 2025-299? I got a message from staff that they thought that maybe one or two places it might have been referenced as 2024.
You have been my guardian angel today. I've been on
Well,
a
no,
roll.
there's somebody else that's being a guardian on this one.
So thank you. If I read
Sorry.
that way, I apologize. It should be 2025-299.
We will
And-
make that correction.
Is that I'm not sure how to correct it since the motion is passed, but it's really a factual. It is what it is. The order is what it is. So, okay, thank you.
Thank you. Ms. Scarborough.
Item number 6 is in docket number 2025-30E. This is a request from complainant Carmen Morgan for reconsideration.
As to item number 6, do I hear a motion?
Chair Powers.
Commissioner Thomas.
Complainant Carmen Morgan filed a request for reconsideration with the Commission on May the 27th, 2025. The request for reconsideration addressed the Commission's directive of May the 22nd, 2025. The Commission has not issued its full written order in this docket. I move the Commission hold complainant Morgan's request for reconsideration in abeyance until after the commission has issued its full written order. Holding the request for reconsideration in abeyance at this time means that the commission will not decide the request until after the full written order has been issued and served on the parties. Once the commission issues the full written order, the parties will have 10 days from the date of the order to 1. File a request for reconsideration, and the request for reconsideration received on May the 27th, 2025 shall serve as a request for reconsideration. Or 2, update or add to a previously filed petition for reconsideration to address specific issues raised in the full written order. After the expiration of the 10-day period for filing for reconsideration, the commission will make a decision about complainant Morgan's reconsideration request and any other request filed by any party. A final order will be issued addressing all requests.
Having heard the motion by Commissioner Thomas, is there any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Those opposed by no. Ayes have it, the motion carries.
Item number 7 appears in docket number 2025-1E. This is a request from the Office of Regulatory Staff for confidential treatment of Omari Thompson's direct testimony that was filed under seal.
As to item number 7, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the Commission grant the request of the Office of Regulatory Staff, or ORS, for confidential treatment of certain information contained in the pre-filed testimony of ORS witness Omari R. Thompson. This information is designated as confidential by Duke Energy Progress, LLC, or DEP, during the discovery process. ORS is required by South Carolina Code Section 58-4-55A to maintain this confidentiality until otherwise ordered by the Commission, or if the utility no longer agrees that such information is confidential and/or proprietary. Therefore, ORS submitted a public redacted version of witness Thompson's testimony along with the confidential version filed under seal. ORS states that although it does not necessarily concede that the identified information is confidential, ORS reserves the right to challenge the confidential designation as it may deem appropriate. ORS further requests that the Commission maintain the confidential version of the testimony as confidential unless or until the Commission rules such information is not entitled to protection from public disclosure or the company agrees that such information is no longer confidential or proprietary. For these reasons, I move that the Commission find and conclude that this confidential information is exempt from disclosure under the Freedom of Information Act and pursuant to Commission Regulation 103-804 S2 and maintained as confidential unless or until the Commission rules such information is not entitled to protection from public disclosure or the company agrees that such information is no longer confidential or proprietary.
Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda, in Part A, we have 11 applications for new Class C certificates that the commission can address together. Item A1 is in docket number 2025-147T, which is the application of Learning to Connect LLC for a Class C non-emergency certificate. Item A2 appears in docket number 2025-148T. This is the application of CLT Rides LLC for a Class C charter certificate. Item A3 is in docket number 2025-149T, which is the application of Trolleys Incorporated doing business as Sunway Charters for a Class C charter certificate. Item A4 is in docket number 2025-151T. This is the application of Sunshine Shuttle of Myrtle Beach, LLC, for a Class C charter certificate. Item A5 is in docket number 2025-152T, which is the application of POC Carolina LLC for a Class E household goods certificate. Item A6 is in docket number 2025-153T, which is the application of Four Corners Entertainment LLC, doing business as Four Corners Charter Services for a Class C charter certificate. Item A7 is in docket number 2025, which is the application of S&B Solutions LLC for a Class C non-emergency certificate. Item A8 is in docket number 2025-157T. This is the application of New Beginnings Diabetic and Home Care Services Incorporated for a Class C non-emergency certificate. Item A9 is in docket number 2025-158T, which is the application of J&H Movers for a Class E household goods certificate. Item A10 is in docket number 2025-160T. This is the application of Dawkins Transportation LLC for a Class C non-emergency certificate. And finally, item A11 is in docket number 2025-161T, which is the application of Flex Transit LLC for a Class C charter certificate.
Mr. Chairman.
As to items A1 through A11 as presented by Mr. Scarborough, is there a motion?
Mr. Chairman, could we get the docket number on item 7 read again? I think it was truncated a little bit. I
Could
apologize.
you repeat that, Mr.
Item
Scarborough?
A7 is in docket number 2025-155T.
Thank you.
Thank you very much. Is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the commission approve the applications for Class C and Class E certificates in item numbers A1 through A11 as identified by Mr. Scarborough. A directive order will be issued for each application in the respective docket. And at the appropriate time, I'd like to say something.
It is the appropriate time.
Thank you, sir. I just want to thank Mr. Scarborough for what it takes to read each of these transportation dockets. And also just note that every time I hear them, I think about where they are represented in our state and who they represent and what they serve. And it's a tiny glimpse into our state, but I appreciate it each time that you read them and appreciate each application. Thank you.
Thank you, Commissioner Williams. And some of the names are very interesting as well. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
All those opposed by no, the ayes have it, the motion carries.
In Part B of the transportation agenda, there are two requests to cancel certificates. Item B1 is in docket number 2022-208T. This is a request from Precious Treasures LLC to cancel Class C non-emergency certificate number 9719.
As to item B1, is there a motion?
Mr. Chairman, I move that we approve the commission grant the request of Precious Treasures LLC to cancel the certificate number 9719.
Thank you, Commissioner Brett. Having heard the motion by Commissioner Brett, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it.
Item B2 appears in docket number 2002-143T, which is a request from Jacob Myers Jr., doing business as Jake's Imperial Limousine Service, to cancel Class C charter certificate number 7222.
As to item B2, is there a motion?
Mr. Chairman,
Commissioner Brett.
I move the commission grant the request of Jacob Myers Jr., doing business as Jake's Imperial Limousine Service, to cancel its certificate number 7222.
Having heard the motion by Commissioner Brett as to item B2, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
In Part C of the transportation agenda, there is one request to suspend a certificate. Item C1 appears in docket number 2023-281T. This is a request from On Time Taxi Service LLC to suspend taxi certificate number 9901 for 12 months.
As to item C1, is there a motion?
Chair Powers.
Commissioner Caston.
I move the commission grant the request of On Time Taxi Service LLC to suspend its Class C taxi certificate number 9901 for 12 months until June 6, 2026. The effect of this suspension means that the motor carrier known as On Time Taxi Service LLC cannot operate or do business as a taxi during this period of suspension, and not until the motor carrier comes into compliance with the Commission's rules and regulations and certificate number 9901 is reinstated. Prior to the expiration of this suspension period on June 6, 2026, On Time Taxi Service LLC, On Time Taxi Service LLC must come back into compliance with Commission rules and regulations to seek further extension or relief from the Commission. And with fear and trepidation, any comments?
Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
In Part D of the Transportation Agenda, there is one request to amend the certificate. Item D1 is in docket number 2024-342T, which is a request from True Transportation LLC, doing business as True Express Medical Transport, to amend Class C non-emergency certificate number 9998 to read statewide.
As to item D1, do I hear a motion?
Chair Powers.
Commissioner Thomas.
I move that the commission grant the request of True Transportation LLC, doing business as True Express Medical Transport, to amend the scope of authority listed on its Class C non-emergency certificate number 9998 to read statewide.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
In Part E of the Transportation Agenda, there are two requests for extensions of time. Item E1 is in docket number 2025-79T, which is a request from Miracle AK Transportation LLC for a 6-month extension of time to comply with Commission rules and regulations.
As to item E1, do I hear a motion?
Mr. Chairman,
Commissioner Britt.
I move on May 19th, 2025, Miracle AK Transportation LLC requested an extension of time for an additional 6 months or until December 5th, 2025 to comply with Commission rules and regulations. I move the Commission grant the request of Miracle AK Transportation LLC until December 5th, 2025 to comply with compliance with all applicable statutes and the Commission's rules and regulations governing motor carriers to operate and use a Class C non-emergency certificate.
Thank you, Commissioner Britt. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item E2 appears in docket number 2025-71T, which is a request from Lila Logistics Transport LLC for a 6-month extension of time to comply with Commission rules and regulations.
As to item E2, do I hear a motion?
Mr. Chairman,
Commissioner Britt.
on May 19th, 2025, LA Logistics Transport LLC requested an extension of time for an additional 6 months or until December 5th, 2025 to comply with Commission rules and regulations. I move the Commission grant the request of LA Logistics Transport LLC until December 5th, 2025 to comply with the compliance of all applicable statutes and the Commission's rules and regulations governing motor carriers to operate and use a Class C non-emergency certificate.
Thank you, Commissioner Britt. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the Commission today.
Thank you, Mr. Scarborough. Thank all of you who have joined us both here and virtually. I particularly want to thank our staff and commissioners for the hard work on these many issues that we deal with. We are adjourned.